What are my privacy rights when sharing medical records? When it comes to sharing your medical records, understanding your privacy rights is essential to protect your personal health information. These rights are mainly governed by a federal law called the Health Insurance Portability and Accountability Act, or HIPAA. HIPAA sets strict standards to keep your health details safe and private. It applies to all healthcare providers, health insurance plans, and their business associates who handle your information. One of your most important rights is the right to access your medical records. You can request to see and get copies of your health records, including details about your treatments and billing, usually covering the past 6 years. This helps you review your information for accuracy and completeness. If you find mistakes, you have the right to ask for corrections. Keep in mind, healthcare providers may accept or deny your request based on medical judgment and documentation rules. They cannot simply remove a diagnosis because you disagree with it. You also have the right to receive a notice explaining how your personal health information is used and shared. This notice, called a Notice of Privacy Practices, should clearly outline your rights and how to exercise them. If you want certain information kept private, you can request restrictions on how your health data is shared. For example, you might ask that your health plan not be informed about specific treatments if you pay privately. Providers are not always required to agree but must consider your request. You can also specify how you want to be contacted about your health information. For example, you might prefer communication by mail instead of phone calls or texts to protect your privacy. Additionally, you have the right to ask for an accounting of disclosures, which is a list of when and to whom your health information has been shared, except for disclosures related to treatment, payment, healthcare operations, or legal requirements. If you believe your privacy rights have been violated, you have the right to file a complaint. You can do this with your healthcare provider or directly with the Office for Civil Rights at the U.S. Department of Health and Human Services. They enforce HIPAA rules and can investigate your concerns. Your health information can only be used or shared without your permission for specific reasons like treatment, payment, healthcare operations, or when required by law. Any other sharing needs your explicit written consent. Healthcare providers are also required to follow the minimum necessary standard, meaning they should only share the amount of information needed for the purpose. For someone managing non-Hodgkin lymphoma, these rights mean you control who sees your diagnosis and treatment details. You can choose to share your information only with trusted healthcare professionals and in ways that protect your privacy. For example, you might request that your oncologist communicates test results directly to you in a private setting, or that your records are not shared with your employer without your permission. Knowing and exercising your privacy rights helps keep your personal health information confidential. It also supports your ability to manage your healthcare confidently and securely. Always talk to your healthcare provider if you have concerns about your privacy rights or if you believe your rights have been violated. Remember, your health information is personal, and you have the right to keep it protected.